More couples today are choosing to live together and not get married. For whatever reason, there's a lot of reasons, maybe financial, and just maybe their personal preference, or just simply some practical considerations. But for whatever reason, there are some couples that choose to live together, buy property together, have assets together, but never get married. What happens to that? Hi, I'm Tanya Hendricks, Huntsville estate planning lawyer, and today's video is about estate planning for unmarried couples. We want to protect shared assets and legacies. So, however it is that couples choose to live together or have assets together without getting married, there are certain unique challenges, particularly when it comes to estate planning. For unmarried couples who have purchased a house together, and share other assets, ensuring the protection of their joint investments and providing for their children from previous relationships becomes paramount. As a estate planning lawyer, understanding the nuances of their situation and crafting tailored solutions for their situation is essential. These unmarried couples need estate planning to protect shared assets and their legacies. So, estate planning for unmarried couples requires a nuanced approach that takes into account both their shared assets and their individual priorities. Think their children. Unlike married couples, who often benefit from some default legal protections, such as spousal inheritance rights when there is not a will, which you should never do, always get a will, and automatic property transfers to property held jointly and with that right of survivorship, unmarried couples must proactively establish safeguards to protect their interests. Alabama law of intestate succession do not account for unmarried partners, no matter how long you've been a couple. So, furthermore, a power of attorney may be essential and required for a partner to transact business and make a decision for the other. Whereas some married couples may get the benefit of the doubt with some things, your unmarried couples definitely need that power of attorney. The first step in estate planning for unmarried couples is identifying the extent of their shared assets. This typically includes jointly owned property, such as a house or investment accounts, as well as other assets they have acquired together during their relationship. It's crucial to document these assets accurately and clearly establish ownership rights to avoid potential disputes down the line. Many unmarried couples come into the relationship with children from previous marriages or partnerships. For these couples in particular, ensuring that their children are provided for in the event of their passing becomes a primary concern. This might involve creating trust, establishing guardianship arrangements, or designating specific beneficiaries to inherit specific or certain assets. With a clear understanding of a couple's needs and objectives, there are several key estate planning strategies that can help them protect their assets and preserve their legacies. Given that unmarried couples often co own property and other assets, establishing a joint ownership agreement can provide a level of protection and streamline the transfer of assets in the event of one partner's passing. Options such as joint tenancy with right of survivorship can ensure that the surviving partner retains ownership of the property without the need for probate. Creating wills and or trust is essential for unmarried couples to outline their wishes regarding asset distribution and inheritance. Wills allow individuals to designate beneficiaries for their assets and appoint executors or personal representatives to manage their asset or manage their estates. As previously noted, Alabama intestacy laws do not provide for unmarried partners. Trusts offer greater flexibility and control over asset distribution, allowing couples to specify detailed instructions for how their assets should be managed and distributed upon their passing. If you want your partner to inherit from you, creating a will and or trust is a must. This is for married or unmarried couples, but specifically for you unmarried couples, it is a must. I am glad to help you and will be glad to help you create those wills and trusts. In addition to wills and trusts, unmarried couples should review and update beneficiary designations on retirement accounts, life insurance policies, bank accounts, and other financial assets. Many unmarried couples choose to keep their checking and financial accounts separate. They just do. These separate accounts may create problems, though, upon the death or incapacity of if that person's account pays some of the joint bills. So, if that person's account pays the mortgage or the light bills, what's going to happen if that person dies or becomes incapacitated and the other partner doesn't have access to that account? So, by naming each other as beneficiaries, they can ensure that these assets pass directly to the surviving partner outside of the probate process, providing immediate access to funds and avoiding potential conflicts with other heirs. Advanced directives, such as the healthcare proxies and durable powers of attorney, are crucial components of estate planning for unmarried couples. These documents grant each partner the authority to make healthcare and financial decisions on behalf of the other in the event of incapacity, ensuring that the wishes are honored and their interests are protected during times of vulnerability. Estate planning is not a one time task, but rather an ongoing process that requires regular review and updates to reflect changes in circumstances, preferences, and applicable laws. Unmarried couples should revisit their estate plans periodically, especially in the event of major life events such as a marriage, birth, or adoption of children, significant changes in assets, or the dissolution of prior relationships. Navigating the complexities of estate planning for unmarried couples can be daunting, but it's essential to seek professional guidance from an experienced estate planning lawyer. A knowledgeable attorney can help couples understand their options, develop personalized strategies, and ensure that their wishes are accurately documented and legally enforceable. And that's what you're here for, right? By taking proactive steps to protect their assets and preserve their legacies, unmarried couples can achieve peace of mind, knowing that the loved ones will be provided for according to their wishes. Estate planning may require careful consideration and diligent effort, but the security and stability it provides are invaluable investments in the future well being of both partners and their families. I'm Tanya Hendricks, Huntsville estate planning lawyer, and if I can help you as an unmarried couple with your estate plan, give me a call at 256-361-1221 or go to my website, huntsvilleestateplanningslawyers.com, and you can schedule directly from the website. That's huntsvilleestateplanningslawyers.com. Thank you very much.